We have a full house today. Well, thank you to Bill, Golan, and Michelle for joining me today and allowing me to host this session for all of you. It's 5 o'clock, well, 5:01, so I'll jump right into our topic. Welcome everyone to Family Law Now After Hours. Today's topic is how to prepare for court. Before I begin, a disclaimer. Please note that the purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided today should not be construed as legal advice. Please feel free to use the Q&A feature to submit your comments and questions. If you have questions regarding your specific matter, please call our office or a lawyer in your area to book a consultation to receive tailored advice. Also, stay tuned until the end as we will be sharing how you can schedule a free initial consultation with one of our lawyers. I will move on to the bios for our panelists today. We have Bill Rogers joining us. Bill is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. We also have Golan joining us today. Golan is an associate lawyer at our firm. He is also a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients and negotiation agreements as well as trial work. He also has experience in negotiating with the authorities to advance a client's interest and has represented clients at various levels of court, including on appeals. Michelle is also here with us today. Michelle Snook has worked as a law clerk exclusively in family law since 2014. She joined Russell Alexander in September 2017. As a law clerk, she works closely with clients to draft various correspondence and court documents. Michelle is committed to providing professional and compassionate assistance to clients, ensuring their needs are met with precision and care throughout their legal process. Lastly, there is me. I'm a family lawyer with a strong focus on compassionate and effective legal representation. I have a background in business management, which enhances my approach to legal matters and achieving settlements through strategic dialogue and advocacy for my clients. I prioritize clear communication, ensuring that clients are informed and empowered throughout the legal process. Now let's jump right into our today's topic, which is preparing for court. Golan, why don't you get us started by talking about the importance of understanding court procedures and knowing what to expect?
Thank you, Shanza, for having us here. Always enjoying these panels and these topics, which are, I'm sure, very confusing to those of us who are not in court on a regular basis. And that's really the importance of understanding that when you go to court, and these days sometimes we go to court in person, other times we go and we attend by a virtual means, by Zoom or video, other softwares that's available. And both of these requires understanding of just basic principles of attendance, respect, understanding the process. Some of it is a given courtesy and manners, nothing to do with any special circumstances of being in court. Just a general courtesy to others when they speak, and respect to judges when they address the court or address the participants. So these are the situations where we want the layperson, the non-professionals one, and those who are professionals who are not familiar with some of the civil or civility that is expected of them in the court when they do attend and have interactions with the fellow associates or unrepresented individuals. So all of that requires some conscientiousness on participants' part when they come to court and getting prepared to address their matter, be spoken to, whether it's whether it's just a case conference that they need to attend to, and some of the understanding has to do with their expectations for that event. What is expected that day? What's the purpose of being there today? Sometimes it's a contested matter that requires argument, and some of it may be factual, some of it might be legal argument. Other situations may just be somewhat informal in some aspect, and do not suggest that there would be an adverse order at the end of that event. Could be a consent procedural matter, such as, exchanging disclosure or things of that nature. So there's all sort of things that we want to know before going to court in terms of the purpose, and that would determine, the preparation of what we need to be mindful of, and maybe have some legal advice on prior to going to court. All of this would always be, under the recommendation of, seek legal advice, even if you don't have a legal counsel in court present with you. It would be advisable to at least speak to a lawyer ahead of time and get the lay of the land prior to attending. That's kind of in a nutshell. I hope it's in kind of an overview of what to expect.
Yeah, no, that was very helpful. And even like for myself, when I'm talking to my clients, like I try to tell them beforehand, this is the type of appearance we're attending. This is what you can expect. Even like little things like, like on the day or the night before, like where to park, what floor, what courtroom. I think just like giving, this basic information to the clients, like they're already nervous, they're stressed out. So the more you can help, the more you can kind of guide them as to what they can expect. I feel like that they appreciate it. Um, Something else that can help clients with court, in terms of feeling more prepared, is showing up prepared with all their documentations. Knowing you're prepared gives you that peace of mind. Michelle, I'll let you kind of take it over from here. And I think you are one of the best persons to speak on this because you're always on top of things. Like every time I email you, you respond in minutes sometimes. So please go ahead. In terms of being prepared, what do you have to say about that? Oh, Michelle, I cannot hear you. Can,
I think nobody can hear.
No, can you hear me now?
Now
yes,
we
I
can.
hear you now.
Oh, okay. I just turned it off and turned it on. That seemed to fix it. Yeah, I was just saying, it's kind of essentially under my job description of making sure that our clients are their documents are in order. And I'm assisting the lawyer as well as the client in making sure that those are put together well in advance of a conference. So I mean, we have financial records, communication logs, etc., that need to be prepared ahead of time, depending on whether it's a conference or a motion. Financial records hopefully are prepared and gathered well in advance. Typically, when you proceed initially with court, you're filing a financial statement right from the get-go. If your conference or your motion is past 60 days of your last financial statement, then we'll be updating that with our clients, which would mean updated bank statements, pay stubs, notices of assessment. If you have a pension, we're hopeful that we have that pension valued prior to your first conference to make sure that that value is included and ready for court. If you're dealing with parenting matters, if you're communicating with your child's parent through apps such as AppClose or Our Family Wizard, if there's any relevant communication logs that you feel would be important for the judge to be made aware of prior to your conference, we want to make sure that those logs are printed out and ready for a conference. They can be included as exhibits in your affidavit and filed with the court. If one of the parents or you are exercising parenting time with your child at an access center, getting those supervision notes ahead of time, again, to either attach as an exhibit to your affidavit or to have available for the judge to review at a conference, whether it's positive or not positive notes, depending if it helps or it doesn't help your case, it's important that that information is put before the judge. So we want to make sure that our clients are requesting that information with enough time to make sure that we are able to serve it and get it filed for our court appearances.
Thanks, Michelle. You're 100% right. I think having everything organized out of time is very important, especially I've noticed sometimes it's easy to lose track of how long it could take to find some documents. So the more prepared you are, the better. Moving on, whether you are representing yourself or appearing with a lawyer, um, how you present yourself in court can really affect the impression you make on the court. Bill, I'll give it to you now. On dressing up, how important is it, do you think, for clients to dress appropriately, and how they present themselves in court?
That's right, Shanza. It is important. If for the lawyer, it's not so bad. At least in Superior Court, we wear gowns. Everyone's dressed the same. In the provincial court, suit and tie. They don't have gowns there. As far as the client goes, I always say, obviously dress smart, casual at least. And Golan, I'm not sure, or Shanza, if you agree with this, but I've represented a lot of fathers who are trying to get more parenting time. And I always recommend a sweater vest just so they look, nice, like kind.
I didn't know that created that impression. The sweater, is that
Well,
sleep?
it's worked for me.
That's good to know.
Yeah. But not a heavy metal t-shirt.
Right. I hear you completely.
Sweater
Bill. In
vest.
fact, I would say that you cannot, I mean, you can overdress if you come with a tuxedo would be a bit much.
Yeah.
But I think you can definitely, if in doubt, suit up, and that would be a decent, respectful way to show up. But definitely, smart casual would be, the idea is to look clean and neat. Nothing to do about. It's not a fashion show, and it's not a try to make a statement by telling the world I don't give a damn about how I look, but rather come with the idea of if you don't respect the rest of the world, at least respect the court, the fact that there's a judge is sitting there and giving you the judicial time to try and resolve your matter or at least assist you with it. So that the idea is really about respect, about some decency and showing cleanliness and like and a fair, reasonable attire.
It's better to be safe than sorry. It's okay to be overdressed than being underdressed.
And the whole Zoom thing has gotten weird too. Like I had a guy who was I guess he was on his phone, he was wandering around smoking.
That is very, I find that very disrespectful. I find judges are really taken aback. Some of them actually making comments and telling you, stop the car,
Yeah, people driving,
put it,
literally
yeah,
behind the wheel.
put it in park or go somewhere where you can actually have the privacy and just stand still because you're making us busy, you know? And that's a very important topic on because a lot of the appearances are now done on Zoom. And the same way that, lawyers and professionals still have to show up with a shirt and a tie and a jacket when they're on Zoom, the same applies to the individuals who are not represented is still required to show a bit of a, clean appearance.
Yeah. And if
So
you're doing Zoom, full touch up.
full touch up and,
I've
it
got
won't,
full touch up on right now, my friend.
that's why you look so pretty.
That's right. I don't look like this at all.
We're fooling the audience. Don't
You have a
confuse.
mask on,
It's
though.
always a good idea to be sober. That
Yes,
long
that's it.
motion we did in Kingston, the poor mother self-rep, she showed up drunk for the all-day motion,
Oh my God,
and
that's
she made it through. It was quite something.
well, if she didn't throw up, that would be an achievement.
You know, exactly. I mean, she was ahead of the game in that regard because she didn't, but it was looking iffy.
Well,
Thank you, Bill. Let's talk about communication. How you communicate in court also matters. Knowing when and how to speak can make a big difference in how your message is received by a judge or even opposing party or opposing counsel. Golan, what advice would you give to someone who's representing themselves when it comes to speaking in court? What should they know about when and how to speak?
well, firstly, communication starts well before you attend to court, right? Because there would be another side. You would be communicating with the other side. You would be communicating with the court, maybe the trial coordinator or maybe the trial office that you would have to send an email to. Um, the first rule is everybody should be on the email, like the other side, all the relevant parties should be included on communication when you communicate with the court, so it's not doesn't look like it's one-sided. The communication itself would be, of course, respectful. You address the person with their last name or their position, whether it's a dear trial coordinator or dear Madam Clerk, whatever it may be, and you end up with the proper the usual courtesy ending to an email. The email itself should be clean, nothing nothing that would be too aggressive, and it should be to the point of what we're trying to get here, whether it's a coordinating how much time it's going to take us to speak, or whether it's going to be whether we have to schedule another date, or we need to adjourn the matter, or maybe we can resolve the issues. Communication about resolution before going to court is also very important, and that's the reason that we try to ensure that the communication is there before going to court, even with the self-represented litigants, because firstly, that's the duty of us as lawyers, but it's also the duty of anybody to that try to consume the court's time, and we have to at least show some efforts to resolve the situation beforehand. So speaking about, that's the pre-attendance, and then you get to the point of the attendance itself. That's not less important is it's all the timeline that goes into this before you attend court, right? Because you have to perhaps send a confirmation in or serve your material ahead of time. All of these, has rules that you have to comply with, whether you're the applicant or whether you're the respondent, and all of the things that you need to be aware of. So there are resources online that you can look into, whether it's the rules, family law rules, or whether it's the practice directions, or if you're lucky to have somebody in the legal profession that can guide you, or like I said before, better have a professional at your side to assist you with all of these administrative issues, as well as the essence of the motion or the conference itself. So once you're in court, communication is, again, this is what I spoke about when I said some of the things are basics. You don't speak unless spoken to. You wait your turn. You listen to the other side. You don't interrupt. Just a common courtesy, first of all. But like we said before, it creates an impression. And the impression could be that somebody is aggressive. So if there is allegation that somebody is bullying in the relationship, and you actually show that trait during your communication at court, you just, you shoot yourself in the foot right there, right? Because you just proved the case without much effort. So that communication style and the pleasantry and the tone of your voice um, and the courtesy that you show to the other side, even when you disagree with what you hear, you just have to wait your turn, and you'll have a chance to respond and say what it is that you disagree with and why, etc., and make your submissions. So that's the kind of I think it's a given that if a judge is interrupting or asking questions, you wait, you listen, and you answer. And when you answer the court, you stand up and you show your respect when you answer the question, and you answer to the point, because otherwise it also seems to be, that's part of the impression. Are you avoiding the questions? Are you going and wandering somewhere else with the facts situation? So that's being focused on the issues at hand, answering to the point, making it succinct. That's sometimes it's more than simply babbling on and going nowhere, because it's just confusing, and you lose the attention. That's I think that the end of it is you lose the attention when you're just repeating your points and going on, just consuming the time. That's my kind of brief take on it.
This was great, and I like how you made a distinction between communication prior to going to court, while in court, and even after attending court, because communication starts from day one, from when you first communicate to the opposing side, and any communication in regards to trying to settle the issue, and then communication continues on as you make it to the court, and even after you've attended your court hearing or court date. Communication is ongoing as you try to further settle your matter. Um, what goes hand in hand with speaking and addressing the court and communication is also proper courtroom etiquette. It's not just about what you say but also how you behave. Michelle, what are some basic courtroom etiquettes and or tips that you think every litigant should know before walking into a hearing?
Yeah, for sure. So I think we've touched on a few for sure already. And I think what's kind of really nailing in is first impressions matter. So you want to make sure you're dressing professionally, and presenting. I generally tell clients that you're essentially going for like a job interview. So dress accordingly. You want to make sure that you're on time. I know for myself, if I'm late for something, I'm coming and I'm frazzled, the tension is high, and you're not presenting well. So it's important to arrive to your court appearance with time for you to go get a drink of water, and just kind of take a deep breath, talk to your counsel, prepare, and be ready to attend that appearance, and just presenting your best self forward. It's important to, when you're addressing when you're speaking to the judge or you're talking to opposing counsel, for instance, when you're speaking to the judge, you're referring to them as his or her honor. With opposing counsel or other sides, it's Mr. or Ms. and their last name. We don't go by first names in the professional atmosphere. Whether you're in person or virtual, no cell phones are permitted. So it's important to turn off your cell phones and turn off, if you're on a computer attending via Zoom, they recommend that you turn off or mute notifications for anything else that may be running in the background, just to prevent distractions and to pull you away from the appearance. With Zoom, there's a few additional things to remember. That kind of changed when the pandemic came, and all of a sudden, like we've already talked about, you're not driving during a conference. You're not walking around the house. You're sitting generally in a quiet and private space where you're not distracted and where confidentiality can't be breached. You're talking about sensitive matters, so it's important to make sure that you're kind of closed off from everyone around you. You want to make sure that you have a stable internet connection. If your internet at home isn't good, finding a private area where you can go where you have a strong internet connection is important, because the last thing you want is for all of a sudden your internet to disappear and you're cut out of an appearance. That's important. Your video needs to be on during a conference, but your audio needs to be muted. Unless you're speaking, unless you're addressed to ask a question, keep your audio muted. Again, it just prevents distractions during the conference, or heaven forbid something happening in the background that you don't want heard. You want to make sure that your audio is muted. There's no eating or drinking in conferences unless you're drinking water, of course, but otherwise, food or drink needs to be left out of the courtroom. With Zoom, we want to make sure that your first and last name is added to your profile name there so the court can identify you. I know for myself, I attend first appearances before Rule 39 clerks all the time, and you just go into a big waiting room, and the registrar will then just move you into where you need to be. So if I'm not easily identifiable, they don't know why I'm there and where I need to be. So adding your proper name or credentials there just lets the court know why you're in that appearance. Making sure your background on your Zoom is appropriate. We're not adding inappropriate images or anything that the court may not appreciate. So either a blurred background or an image such as the one that you three have is suitable. And also, it's important that we're not recording. We're not recording the Zoom appearances or conferences. It's strictly prohibited. So no audio or video recording allowed.
Thanks, Michelle. Those were some great tips. I know we all tend to have these questions at some point, and we never know who to turn up to. So thank you.
Yeah, there is also like on the Superior Court website, I do often will provide that as a link to my clients. It provides a yes or no courtroom etiquette list for clients. So generally before their first conference, I'll send that to them as a resource. It also helps them with their nerves as well, to calm them down, as to know how they can expect to behave or prepare.
Great. I think we can include this in our show notes today after the session for our audience as well, just so they can refer to it as well. And I think something else to kind of also add on to here is family law in general is emotional, which kind of makes stressing on court etiquette more important. It's important for clients to separate their emotions from how they treat others, how they treat court staff, how they treat opposing side, how they treat the judge. Even if you're feeling frustrated or hurt, Golan kind of spoke on this too. That shouldn't come across as disrespectful toward the judge or the other side. And speaking more on emotions, whether you are representing yourself or you have a lawyer, one of the biggest things to keep in mind, and honestly, one of the easiest things to forget when you're feeling stressed or overwhelmed, is trying to keep your emotions in check. And while you are in court, you do want to make sure you are focusing more on the legal side of things. I know it's hard, especially in family law. Things do tend to get more emotional, especially if you're dealing with your kids, your home, your finances, your whole life, really. But when you are in court, it's not the place to vent or to get everything that's gone wrong in the relationship out in the open. Judges don't want to hear a play-by-play of who hurt who. They do want clear, they want relevant information to help them make a decision. If you are self-represented, it might be a good idea to maybe write down the key points that you want to get across on your court date. Keep it focused. Focus on questions like what happened, when did it happen, why does it matter to you legally, why does it matter to the legal point that you're trying to make. You want to avoid long stories or side comments on what the opposing side is saying. You want to focus on the facts, and you want to focus on what supports your position and what you're asking for. Again, you don't want to engage in a back and forth argument. You want to be respectful to everyone. And if you do have a lawyer, or your job is to give your lawyer a full picture of what's going on, the bad, the good, all the details, and then let you work with your lawyer as to what's useful to raise in court, and trust your lawyer with that process. So bottom line, feelings are valid. But you do want to keep your cool, you want to stay focused, and you want to be prepared. Going back to attending court, something else that's important, but we don't talk about much is, sorry, showing up on time. And by time, I mean early. Michelle, what do you have to say about arriving early, arriving on time? Do you have any advice for people to ensure that they arrive early and prepared for their hearings?
Yeah. So with virtual appearances, I generally recommend that my clients log in. I usually say about 15 minutes in advance of your conference. This just allows you to make sure that you have any tech issues ironed out before the appearance starts. Whether it's internet or connection issues, if you have the wrong Zoom link, it gives you that time to figure that out. So you're not scrambling either 1 minute before or a few minutes after. You're sitting in the waiting room and waiting for the judge to permit you entry once they're ready to proceed. If you're attending in person, again, this depends on whether or not you have spoken. If you're attending self-represented, I would say probably about a half an hour. You want to make sure you're there in advance to make sure you are able to find parking, get through security, and then get up to the floor and locate where your courtroom is. Again, it allows you the time to have a restroom break or grab a drink of water, take a deep breath, and just prepare. If you have counsel and you've spoken ahead of time and there's no need for you to speak ahead of the conference on the day of, you could probably stick to that hour rule. Or you may speak with your counsel ahead of time and agree, hey, let's meet up an hour and a half before the conference so we can discuss any relevant issues prior to the conference starting. But yeah, general rule of thumb, I would say for in-person appearances is for sure at least half an hour before. Parking could be down the road for some court locations. So you want to make sure that you have enough time to get into the building and through security.
Thank you, Michelle. Just last week, I attended court with my client and we arrived an hour early and we were able to enter into a consent prior to the case conference. Yay.
Amazing.
But it
Amazing.
can help. So yeah, I mean, arriving early can definitely, it has its benefits. So it's best to maybe try to even utilize that time to enter into potential settlements with the other side. If you have your lawyer, then that definitely helps as well. If we are talking about arriving early, I think it's only fair that we also talk about court delays. Bill, I defer to you. What advice do you have for clients on how to stay patient and prepared when facing delays in court?
Well, Shanza, your experience of entering into a settlement during the waiting period before the appearance, that happens quite a bit. And before Zoom, what they do is they'd say, your motion is going on at 9:30 a.m. or sometimes 10 a.m. at the court. And you get there and everyone gets there at 9:30 or 10. And what the judge does is they go through the list of matters for the day. And the first ones they do usually are the routine matters that they can do quickly and get out of the way. So there's usually a lot of waiting time. If you have a substantial motion that needs to be argued, you're probably not going to go at the very beginning. You'll be waiting. And that's a great opportunity out in the hallway to maybe talk about settlement. And that happens a lot. With Zoom, correct me if I'm wrong, I think I've heard stories of people waiting on Zoom for quite some time. It's like the hallway, but it's not the hallway. You know what I mean? Does that happen?
Well, that's because you have to specifically ask for a breakout room with the other side. Otherwise, you're just being in a waiting room
Right.
with,
Yeah.
you know,
So you go to
looking
the
at the
breakout
walls.
room and then it's like the hallway and maybe you can talk settlement there.
Yeah.
But I used to say, I don't know if it's the same, like I think they're scheduling for specific times of day more than they used to on Zoom anyway. But if it's in person, I always say to the client, like, book the whole day off. Like, don't plan on getting back by, 1 p.m. or something. Like, you got to plan for it. And
So, absolutely.
you know what I mean? Yeah.
Yeah, I absolutely agree with you. By the way, my wife tells me often whenever I'm on time, she tells me you're late. So being on time means you're late.
Being
So take
early,
that
that's
in,
right. Exactly.
yeah, take that into consideration that you have to be there well ahead of time, and don't think that security is a quick thing. It becomes almost like an airport, depending on which courtroom you're going to. I've seen lineup all the way to the outside of the building at sometimes, so that can take half an hour by itself. But
Plan
again,
for the whole day. It's a good
yeah.
idea. It's
It's
not really,
definitely gives you the
yeah.
time to consider all the option, have a chat, give instructions you are represented, have a chance to somebody to speak on your behalf. If you're not represented, I do not know what's the deal with the duty counsel on in the courthouse, whether they offer assistance in that regard, but that's something that may should be explored by those who don't have legal representation, so somebody can speak on their behalf. And Shanza mentioned earlier the issue of everybody being emotional in the family court. That's one of the reasons that we also saying that it's better to have representation to kind of guard you from yourself, really. Just guard you from yourself because you may not be speaking appropriately or just showing too much emotions that are not relevant to or can hurt your case. So
One of the
that's
most, divorce is one of the most devastating things a person can go through in life. And what you don't tell your client ever is don't take your divorce personally. It's really unhelpful.
would not be helpful.
Yeah, do
And
not say that.
Shanza mentioned, tell your lawyer the good and the bad, and I add and the ugly as well. Because we need, when you have a legal representation, you have to realize that that person is on your corner and should not be surprised with anything, with any curveballs that comes by way of facts that he was not aware of, or was not made aware of.
I've had the
So,
pleasure of learning very important facts during a trial on more than one, two trials that happened to me.
and how pleasant
Turned
is
out
that?
my client was lying to me for a long time and it all came out.
No.
It happens.
I had a client that was requesting a restraining order, and then turns out that they had sex the previous day.
Oh dear.
Can you imagine? And I hear that from the other side say, by the way, just so you know.
Golan, I'll actually say on you, Golan. I mean, you kind of like brought back up, emotions and kind of having the lawyer on your side helps with communication, right? Even on the court date, because your lawyer tends to know what to filter out and what to say to the judge that's more appropriate, and more relevant. Speaking a bit more on communication, would you have anything more to add about interrupting the other side and how to kind of deal with arguments or anything along that sort during cases?
Well, the thing is that we cannot do a quick 101 legal course on how to present all the legal arguments that are relevant to one's case. That's the reason that we have a job. And that's kind of differentiate between the self-representatives and the legal representations, because the self-reps can really focus on the facts. They know it better than us. Only that they need to filter what's relevant and what's not. And this is where a professional assistants make a difference. On the legal arguments, again, there are those who are capable of doing their research and finding out things appropriately. Today's the online and digital resources are quite helpful. Need to be scrutinized very carefully, but at least you can really have a lot of information available before your matter proceed, and you can kind of gear your arguments accordingly. Yeah, but for a proper, let's say a more focused argument and legal submissions, you want to have the representation in court. Like I said, there are those who are able to do that, and there are those who may be lacking that ability, and that's the reason they chose a different profession, I suppose. But that's really the key difference there. It's either you can focus on the facts if you self-rep, and you try to make it to the most relevant one that would make your case, would make your the relief that you're seeking or the argument that you bring forward. And the legal argument tends to be more technical in nature, and then we kind of apply the facts to the principles and to show how it fits the argument and the relief that we're seeking when we present the argument. So it's kind of a puzzle that we try to make a better picture for a judge before he or she makes a decision. But that is really the main difference, and I say, it's really personal abilities that we're talking about here.
Well, and I saw a self-rep one time make a dramatic gesture, and he held up a document way above his head, and he said, "Your Honor, I have proof that she committed adultery." And I'm thinking, it's not 1965. Back in 1965, if you committed adultery, they would punish you for it, like you wouldn't get spousal support. But in 1969, no-fault divorce came along, and you don't get punished for adultery anymore. But a lot of people don't know that. Like if you're a self-rep, and it was kind of sad.
That's the thing, that
I don't know.
They focused on these fault issues to try to create that sympathy,
Yeah.
or to tilt the scale, and don't realize that it's really not relevant to the situation right now.
Although it should be. I mean, if you commit adultery, you should at least get a ticket. Don't you think? Like a speeding ticket? I don't know.
A minor fine.
I can think of many offenses, whether it's on civil liabilities or
That's
something
what I
like
was gonna
that.
say. What does the criminal lawyer in Golan says about this?
Yes, Golan's a great criminal lawyer, and I hope I never need you, my friend.
Appreciate that.
All right, thank you,
He's the
Golan.
best.
Moving on, Bill is always telling us that we can't always know what to expect on the court and what's going to happen. Things can go sideways. You can never know what's going to happen on the day of. So it's always smart to plan ahead and have a backup plan in case things don't go as expected. Being ready for different outcomes can keep people more focused. Bill, how can clients prepare themselves for various outcomes in court, and why is having a backup plan, a potential solution, or important for them?
Well, I always say I recommend you start drinking heavily because it's gonna go badly no matter what happens. I mean, it's not a drive-through, you know? Let's see, I'll have sole decision making. I think I'll take a side order of spousal support, and I want a public execution of my acts. And I say to my clients, you know what? You're not wrong to be angry, and you're not wrong to want justice. And in a way, almost you're not wrong to want revenge, although I don't know, that's a little extreme, but the judge usually goes somewhere in the middle, I find. I mean, it's very hard to win big in family law. So I always say, like, you know what? I know there's a lot of hard feelings, and I know you want quote unquote justice, and justice is the goal of the system, and we do try for that. But I think a lot of people just they feel so hurt and so wronged, and a lot of times they're 100% correct. And I say, you know what, you're not gonna walk out of there thinking, oh, I finally was vindicated. And the other thing too in family law, and Shanza kind of mentioned this earlier, they don't want a play-by-play of who hurt who. What you find in a family court is they want to look forward, not backward. That's especially if there's kids, because that's the best way to go. And you know what? What happened in the past is bad. Yeah, you did get treated unfairly, bad things happened, but we can't change that. And instead of trying to get vindication or whatever, we want to look forward and see if we can improve. And people do improve, and it does get better, and we can do a lot of good. And that's what I try to prepare people for. You know, it's not going to be a big win and you walk out of there saying, I was right. It just doesn't work that way. I mean, occasionally it does, but mostly not.
Probably I tend to, everything Bill said is to the point. I would even say more than that, you know how a client is seeking all this extreme relief, that is sometimes nothing to do with being reasonable. And this is where you try to kind of pull that person out of the self vengeance type attitude and just say, look, just you be the judge for a moment. And here you have the children, and they have two parents, and they should be having relationship with both most times. And the idea of all of a sudden treating the children as a private property doesn't no doesn't work, and you want to break that to them. But firstly, when you self-rep, it's more of a problem because you kind of educating yourself, and you don't have anybody to give you, or maybe you do, but sometimes you're getting bad advice as opposed to a proper advice, because it's easy to give free advice by people who are not professionals and are not going to live the consequences of their ill advice. So that's one thing that people have to think about when they listen to the neighbors or the friend that had gone through the same, and there's nothing looks the same, but they always think, oh, they went through the divorce, I will have the same outcome like they did. And it's never like that. And that's one of the things that we try to educate the clients to see the reasonableness of their particular situation. And that's normally this is where it tends to go. This is our prediction of how a judge is going to determine a matter if it's contested, or even if it's in a conference and you want to seem reasonable, you want to put on the table a situation that would be endorsed, that would be supported by a judge hearing your side. So that's the reason that having expectations that things are not going to go your way, and having low expectation is one way not to be disappointed, especially if you are at the extreme position. And that's the backup. The backup plan is to be prepared for a reasonable position. That's the backup plan, really.
And you know what, Golan, that's a win. I mean, the way I look at it is, unless there's abuse or neglect, and by the
Right.
way, every client thinks that their ex is abusive and neglectful, but I'm talking really bad abuse and neglect. Unless those are there, shared parenting,
It's a win.
shared decision making, that's a win. That's a win for the kids. And a lot of clients, just out of anger, and it's I tell them, you're right to feel this way, but it's a win to share decision making with your ex, because otherwise you have to explain to the kid why daddy is unfit to even be in the loop of decision making, and that just makes daddy a loser in the eye of the children, and that hurts kids. So again, unless there's abuse or neglect, shared decisions, shared parenting time is best for kids. And if you can, it takes time to bring people around to that, but that's a huge win for the kids.
Yeah, like you're saying, it's subject to specific circumstances of each case. Generally speaking, I tend to agree with that approach. It's definitely, but that's the reason that we want people to kind of step out of their personal misery and just look at the best interest of somebody else, which is kind of it takes a lot of a lot of energy and focus to not be just boggled down with what's hurting me and how am I making myself feel better,
And it's
right?
super important though to tell the client, you're right to feel that way. There's nothing wrong with you. And yeah, it is a bad situation, but again, the long-term benefits to the kids of being civil and trying to share parenting and decision making, it pays off huge, huge.
Thank you, Bo and Colin. I think these comments by the two of you, I think really highlights the role that we play as lawyers in managing client expectations. I think it's hard to tell clients it's not easy to get everything they're looking for in court, and um, it's not easy for clients to sometimes to hold reasonable positions, but part of our job is to help clients understand what's realistic and how they should focus on what's most important, which is if there are children, best interest of the kids, always. Well, thank you, everyone. Thank you, Bill, Colin, Michelle. Thank you to our amazing panelists for joining us today and sharing their insights. And thank you to our audience for tuning into our Family Law Now live session for today. We are approaching the end, so I'm going to just conclude our session. Following this Zoom, everyone who is joining us through Zoom will receive a brief survey, which will allow you to share your comments and your suggestions for future topics that you would like to explore. So please feel free to fill out the survey. Um, I
Are they
promise
going
you,
to be commenting on this presentation?
yes,
My name is Russell Alexander.
Only for the bad comments, right? But if it's good comments, it could be Bill.
there'll be amazing comments though. Um, But thank you, everyone. Initially, I did mention that you can receive a free complimentary consultation if you join the session to and stick to the end. You can do that by reaching out to our intake team at intake@russellalexander.com. And please provide the code SPRING 2025. I know it's so cold today, but we're heading into spring, so I'm using this code. Registration is now open for our next event addressing false allegations made by your ex. In order to sign up, just go to our website at russellalexander.com/familylawnow. Well, thank you everyone again, and thank you to our audience for tuning in. Have a good night, everyone.
Thank you.